All right, good afternoon. Thank y'all for all being with us. Appreciate y'all's good testimony y'all had last week. Thanks to Chairwoman Silcox for doing such a good job in our absence. And so if y'all would just bow with me real quick. Almighty God, we come to you today, Lord, with thankful hearts, but also with hearts that go out to the family of the slain officer from Roswell, Georgia. Lord, we ask that you comfort his family, Lord, as only you can do. Lord, we ask that you be with us here today. Help us to carry out this business that would be pleasing and sufficient to you, Lord. In your name we pray. Amen. All right. So good to be back. Thank y'all for coming up here. I've got to at least keep some people with a job still. I've got a few DAs. I'll start out with one I've known the longest, Mr. Winnie, and his boss, the head district attorney for the Coweta Circuit. Even though we got a divorce last year, he still wants to come around. So that shows amicable divorce. I also have Mr. Earl Newton from up in the Cherokee Circuit, which encompasses Bartow and Gordon counties, not Cherokee County, Georgia. Just fun fact for you. He's actually my first cousin's boss, so that shows you the Smith side's got both sides covered. Also want to recognize Miss Donna Coleman Stribling, Solicitor General for DeKalb County. Appreciate y'all being here. And then last but not least, Mr. Bill Finch from Forsyth County, Georgia. Good solicitors and good DAs with us. Have I missed anybody? If I have not meant to offend. All right. Anybody with a robe that I may have? Oh, yes, and from the Lookout Mountain Circuit. Appreciate y'all. Name one more time. Clayfolder. Good to see you. I'm kind of like the 3 times I hear it, I'll be fine. But anyways, thank y'all for being with us. Nobody in a robe? Or, okay. Who? Judge Weaver from up in Jasper? Yes, went to school with George, her son. Okay. Well, let's get down to business. First bill we're going to hear is House Bill 162, Representative Lisa Hagan. The Vidalia Onion Queen. Good afternoon.
Thank you, Mr. Chairman. And members of the committee, appreciate y'all taking the time to hear this bill today. We appreciate it. I have right here with me Wade Askew with the Georgia Justice Project. I've been working with him on this bill for a couple of years now. So, Mr. Chairman, if it's okay with you, he'll sit here with me and answer any of the questions that I am not qualified to answer.
That'll work. I recall Apostle Paul had a lawyer and a doctor with him. So.
Well, if there's a doctor in here, I'd be happy for him to sit up here next to me as well. I'm happy to take all the help I can get. Well, members, if you will remember, if you were on this committee last year, this was House Bill 909. We called it the First Offender Modernization Bill because that is exactly what it does. A little bit of history. The First Offender Act was originally passed in 1964 so that those accused of certain crimes would have the opportunity, and it's their first offense, would have the opportunity upon successful completion of their sentence to have their records sealed, and is considered a non-conviction. So because everything is online now, we've heard from many people who have taken advantage of the first offender plea share that because their records are already online and they're not sealed until after the completion of their sentence, which is typically probation, that it's rendered the First Offender Act as in many cases ineffective because these records are already online and searchable and found. So our goal here is to simply help these people who have made a bad choice. The judge has determined that they will accept that first offender plea, and if they do not have have a reason to revoke that plea, we want them to have that second chance. We want to make sure that when people make a poor decision, that if they determine they're not going to make any more of those poor decisions, that they can go on with their life and not have a conviction interfere with their ability to take care of their family, have a good job, find good housing. So, Mr. Chairman and members, we have worked very carefully with several groups, GBI, Pardon and Parole Board, prosecuting attorneys, the judges and court personnel, Department of Community Supervision. We also work with financial institutions, including the credit unions, to make sure that they would have access to these records if they needed to look at somebody for employment. So we've attempted to make sure that everyone who would need access to these records would have access to these records. But what the bill does is just ask that a judge who accepts a first offender plea would have the records sealed upon sentencing instead of upon completion of the sentence as it is now. And that judge in the bill would retain the right to revoke that sentence at any point, and the judge would still retain the right to not accept that plea if there's extenuating circumstances and they determine that that's not appropriate for that particular offender. So, Mr. Askew, if I've left anything out, I'd love for you to fill it in, but I'd also be happy to answer any questions anybody has if I could.
Mr. Askew, do you have anything you wanted to add to that? Okay.
Nothing to add. Happy for questions. I will say, from the State Board of Pardons and Paroles, we have a very extremely brief, friendly amendment that we'd be happy to offer that they had asked for, and we're happy to include the addition of their name at line 182, and that's about it. Otherwise, this is essentially the same bill that the House unanimously passed last year. The only way it looks different from the House version last year is we worked very closely with the judge to make sure that operationally on the ground things will be as smooth as possible for all actors who need to be able to see these records.
Okay. All right, number 14, Representative Hong, or Floor Leader Hong, I'm sorry.
Thank you, Mr. Chair. Thank you for the bill. I know we heard it in the subcommittee, and I remember there was a question regarding civil cases where civil attorneys may need to access this information. Were we able to clear that up?
We were. I'll let Mr. Askew address that if that's okay.
Yes, thank you, Floor Leader Hong. So at lines 188 and 189 of the bill, as well as I believe it's 236, essentially we have these lists of who can have access to a sealed record and when. One list represents while someone's still under a First Offender Act sentence, and then another list for once someone's successfully discharged. In both those instances, we have the language that when such records are made available for inspection, copying, and pursuant to a court order, pursuant to a court order should allow any civil litigator to the very beginning of their case ask for a court order to say we'd like access to relevant conviction records, First Offender Act sentences that are currently under seal, and we think that should, as a matter of course, be able to enable civil litigators to get what they need.
Okay, we're lighting up like a Christmas tree up here. Okay, Chairwoman Silcox.
Thank you for bringing this bill on. I think it has important policy implications for employment and housing and so on, like you said. My question would be, so if someone pleads, the first offender, and their records are sealed, and then they mess up their probation or they do something wrong, then what happens? What if?
So if their status is revoked, which, as a side note, we actually asked for GCIC data to have a better sense of how often folks are revoked. And since 2017, the data that they sent us said only 2% of cases are. So, this is typically a population of folks who it is that one-time mistake and have a very heavy incentive to do well.
Of course.
But if it is revoked, then the law explicitly says, if it is revoked, a conviction is entered, then it shall be made public. It is a shall.
Okay, great. Thank you.
Number 7. Let's see, that's Representative Panich.
Thank you, Mr. Chair. Thank you for bringing the bill, Representative Hagan. My question is, if we're going to allow access to civil lawyers, and the idea is to keep all this information protected. Will there be a protective order required for disclosing the information, to disclose the information to the civil lawyer?
So that's a good question. As the law reads right now, it would just be that lawyer would have to put forward a good reason to the judge and obtain a court order to get the records. It does not dictate then when that lawyer has the records that there is a protective order, or they essentially have to do their own version of sealing. From there, it doesn't specify that.
So it's up to the judge, essentially, to impose a protective order, because there's really nobody on the other side.
That's
The
right.
civil lawyer's trying, well, I guess the defense lawyer would get notice as well.
That's right.
Okay,
Yeah, so it'd
that
be
actually
parties
is
of that
better.
civil litigation would have notice, and it would be, again, for the judge to decide.
Okay, so the defense lawyer will have notice of this hearing, or this proceeding, and can then request one if they want to.
That's right.
Okay,
Yes,
thank
thank you for
you.
clarifying.
Number 16, I believe that's Chairman Leverett.
Yes, Mr. Chairman, thank you. Thank you for bringing the bill again. One or two quick questions. Is this substantially the same as what you filed last year?
Yes.
Okay. And the scenario that Representative Panich was discussing, and the court order provision that you've referenced, I'm assuming that would be in a context of the defendant who has utilized the first offender statute to plead, would then be, if he or she is then sued in that civil litigation, the plaintiff could request an order requiring disclosure of the protected information.
That's
right.
correct. Or if that individual were a witness in a civil case and a lawyer felt like they wanted that information for purposes of impeachment, so the counsel would need to, provide reason for relevance to the judge. Just existing evidence law, we think, covers that.
Would there be any notice requirement if the defendant is or if the first offender, let's say, is the defendant in civil case, they would get notice of the effort to access the record. If they're a witness, I haven't had this issue come up any. I can't remember. If you move to obtain information about a witness's criminal record, is that necessarily something the witness, who's not a party to that civil case, would have notice about?
I don't believe so. This is where my limitations on the criminal side versus the civil side might kick in, but to my knowledge, it's the same as yours.
Okay, all right. And the other question, and this may be something the chairman would care to take up later, just I wanted to clarify the amendment. You said the friendly amendment, exactly where that is, and are you adding to the list right below line 182, Department of, was it pardons? Or
So, thank you for that. So at line 182, the State Board of Pardons and Paroles, their proposed amendment to us, which looked good to us, is to add to paragraph I there, the Department of Community Supervision and the State Board of Pardons and Paroles would be the exact text. So they would both be listed in sequence under paragraph I at 182 is what they suggested, and we're perfectly happy with.
And just one follow-up, Mr. Chairman. Are we putting them in the same exception? Are they both affiliated agencies?
So, when we originally, it would be our understanding and stance that they would all be covered as criminal justice agencies, which are already recognized under law and part of this list. But both, we know that when the rubber meets the road and we might be, trying to get records from clerks from across the state, that having something explicit can
Always
just
helps. Yes.
be helpful in expediting that process. And so that's why they are explicitly there, because these are the parties most likely to really need something.
Well, my question really was one more to formatting.
I think another letter would be
Another.
necessary.
That was my thought. Unless they're the same affiliate agent, I don't think they are. I think they're separate.
Yeah,
agencies.
they've got a board that covers them too,
Yeah.
so a little different entity.
We're happy with that.
All right.
Thank you, Mr. Chairman.
Thank you.
Number 13, Representative Burton.
Thank you very much for this bill. Certainly, people do really stupid things, so we hope that we could get them back to work or whatever they need to do. My question is, does this remove in any way judges' discretion
No, ma'am. No, we would not want to do that. Currently, if a judge chooses not to accept a first offender plea, they have the discretion not to, and that does not change with this bill, correct?
That's
We do not
correct.
want to change that at all. We know just because someone could, under definition, plea first offender, there always are extenuating cases where that a judge may need the ability to not allow that plea. So that remains intact with this bill.
Very good. Thank you.
No other questions. We'll move on to those who want to testify on the bill. Let's see, Sarah Lou with the GBI. Is Sarah here?
Chairman, that's for the next bill, I believe.
Not Siri, sorry. Siri was in her dadgum techno. Okay, sorry about that. All right, I got, Wade, do you want to come back up and say anything? Brevity, love it. Okay. All right. I don't see anybody else. Anybody else come in late that wants to testify to it? All right. Let's see, number 7.
I move to pass.
Okay, got a move to pass. Second. Move to pass in a second. Any amendments? Let's see, Chairman Labour.
Chairman, I would move that we amend the bill by inserting below line 182 a new letter, or inserting a new J, which would be, I think, is it the Board of Pardons and Paroles? Is that the proper name of the agency?
I believe so.
And then re-lettering the remaining paragraphs. And then do we need to do the same amendment?
What line again was that, Wade?
It was between lines 182 and 183. That's right. And does the subsequent section need a similar amendment, or is it just in that one place?
It had not been requested. It had only
Okay.
been in that one place.
Okay. So that would be, I think, the motion, Mr. Chairman, just to make
Okay.
that amendment right there in that one spot.
All right, got a move and a second to incorporate the State Board of Pardons and Paroles within the list of these agencies and the corresponding re-lettering of those sections. All those in favor say aye.
Aye.
All those opposed, same sign. Okay, the amendment is on. We got a motion to pass an amendment. All those in favor of the passage of House Bill 162 LC number 481348, say aye.
Aye.
All those opposed, same sign. All right, it passes. Congratulations, you're on the rules. Thank you. All righty. Next, we will hear from Representative Brad Thomas, House Bill 171.
It's uncomfortable. You getting any sleep?
A little bit. Tell us what you got.
All right. I'm here to present House Bill 171, LC number 492207S. A bill that aims to address distribution of computer-generated obscene material depicting children and enhance sentencing of crimes committed using artificial intelligence. It does so pretty much mostly in Section 2. The section amends Title 17 to introduce enhanced sentencing for defendants who use artificial intelligence in the commission of certain designated offenses. It outlines the process for notifying defendants of enhanced penalties for those intentions, or the intention of enhanced penalties, the determination of AI involvement, and the specifics of enhanced sentencing, basically creating a framework for increased penalties for crimes involving artificial intelligence, leading to longer imprisonment and higher fines for convicted individuals using this technology. Actually, I'm sorry, I skipped Section 1, but Section 1 enacts a new section to prohibit the distribution of computer-generated obscene material depicting children. Increasing
What
legal,
LC number are you working off of?
it should be 2207S.
Okay, just
is that
wanna
what
make
you
sure.
got?
That's-
Yeah, I'm sorry, I said section. Yeah, so just so you all know, I had the flu. I'm back. Bear with me here just a little bit. So don't worry. Doctor cleared me to come, so we're okay. But I'm on cold medicine, so bear with me here a little bit. I'm getting there. And let's see here. Otherwise, key definitions. The state it actually codifies now what an artificial intelligence system is. This is something that we've worked on pretty significantly over in the technology committee over the last several. Actually, I would say almost 2 years now. Additionally, it defines a child as anyone under the age of 16. Sexually explicit conduct, it just refers to 16, 12, 100. And then designated offense. Now it includes designated offenses for this now includes stalking, exploitation of vulnerable individuals, enticing children for indecent purposes, and fraudulent election interference versus other things. And so I just wanted to walk you through it, but then I wanted to talk to you about the intent of the code and kind of what we're trying to do here. None of these crimes are new, y'all. Fraud's been around for a long time. It's no different. As a matter of fact, most of these crimes in here, probably most of them are some of what I call the originals, have been around for a long time. What issue that we're facing now is we have technology available that makes perpetrating these crimes not only significantly easier, but it also makes it more believable to the person that this crime is being perpetrated on. It's I would say some of the most heinous crimes, specifically the exploitation of children. If anybody's familiar with how training an AI data set works, they scrape images of real children right off Facebook. It could be your kids. And they take those images and they train an AI model on what a child should look like. And then they use that image to create obscene material. It's not a real child. But I have to tell you, if my child was one of those ones that were used in that data set to train that AI model, I'd have to tell you that hurt me just as much as any other unimaginable thing that could happen. And so because of that, there's a lot of concern that by not directly addressing the fact that it's not a real child, that it provides a loophole in the criminal system for criminals to use this. And quite frankly, it's used to lure really, sick individuals into the dark web where it does feature real children. And that we got anything we can do to stop that, I think, is a measure worth putting in front of the General Assembly. So with that, I'd be happy to open it for questions or comment, and we'll go from there. Thank you.
Thank you. Appreciate that, Chairman Thomas. I know you've worked hard on this and have worked with our office on this a whole lot, trying to make sure we get this right. Number 7, Representative Panich.
Thank you. Thank you for bringing this bill. I've represented kids who have been victims of pornography, of child sex abuse with pornographic images. And I've also been appointed to represent people who've perpetrated them. So it's a terrible thing. And I'm glad thank you for bringing this and closing this loophole. I have 2 questions. Mm-hmm. First, why only the enumerated crimes? Why wouldn't this apply to any crime?
I'll be quite frank with you. I don't know the answer to that question.
Okay.
I wish I could give you, but I think that it's probably these are the ones that specifically touch things that we know that AI has the ability to do. I'm not sure. And again, I'm not an expert in this particular piece, but I do believe that these crimes that we did enumerate, you can actually tie there being cases to this to AI versus. Not enumerated. I don't know how far or vast you would get at that point. I guess it's always better go with a tighter script at first and then loosen it up. But
I guess it depends on what your view is. But I think if we're enacting this, I don't know what shouldn't be included. But we can discuss that offline. My second question relates to kids who may engage in AI. 17-year-olds, 16-year-olds who are stupid and manipulate an image and send it to their friends who are also 17, 16, 15. Is there an exception that we can make in here so their punishment is not, or that they wouldn't be charged with this? Because I don't think the
think
intent
that's a
is the same.
I think that's probably a good policy question. To me, I'd say if you were the father or the daughter that had that particular thing spread around you, I think I'd be pretty upset about it, even if somebody was doing, especially with obscene to the level of obscenities. I would be happy to always have a conversation with you about it, but currently that's not the way that we have it constructed.
Okay.
So, yeah, thank you.
Thank you.
Well, let's see, number 14, Chairman Gullett.
Thank you, Chairman. So two quick questions on this. One, I think, tell me about the aggravated piece of this. So I know there's an aggravated for the obscene, right? So that's an aggravated crime. And then I think that's like around lines 45
64.
or somewhere.
Oh, okay.
Am I right? I think 45. And then and then my second question is, how are they prosecuted today for crimes like this?
That's something I'd have to defer to PAC on,
Okay.
how they're being currently prosecuted.
Yeah.
And I believe PAC is here to speak.
I got plenty of prosecutors and
Yeah, I was going to say,
solicitors,
there's a lot
I
of
mean-
people a lot more familiar with the legal system that
Yeah.
can answer those than myself. I can tell you the intent of the bill, and I can tell you what it does, but how the legal system works, I can't necessarily. I'm not.
10-4. So I guess just tell me about the aggravated piece. So it's making if you commit the offense of distributing computer-generated obscene material depicting a child, shall be guilty of a felony. So we're just basically, from a policy standpoint, saying if you're doing this about children,
Mhm.
that's really bad for us.
I think it just clarifies that depicting an image of a child, and it doesn't necessarily have to be a child,
Yeah, real
right?
child, right.
It just depicts the image of a child, which
Sure.
changes a little bit of, I think, the intent, the way the original code was saying, where it says depicting a real child,
Yeah.
right? So that's the clarification here,
Yeah.
which is, we're really trying to go after the activity. Again, it's a different way to get at the same crime. I mean, you're taking images of real kids and you're putting them into an AI, training the AI on real child's faces, and then creating not
kid.
real child,
You're right.
but it's still a child nonetheless.
Yeah.
So I think that's a great question. Thank you. Hopefully I answered
Yeah,
it.
you did, and I appreciate that part of it for sure.
I thought Ed Setzler was back on the committee for a minute. Let's see, I think I had number 16 first. Is that Chairman Leverett?
That's a tough comment to follow, Mr. Chairman.
Yeah.
So, as I understand the bill, you're doing two things. One, you're creating a new crime that does not currently exist, and that would suggest to me that these cases, that it's maybe possible to prosecute what's defined here using some other statute, but it's probably not working terribly well. And then you're also providing for an enhancement if certain other crimes
Right. Yes.
are committed using an artificial intelligence system as defined
That's
in the
correct.
statute.
And the intent, thank you for that, Chairman Leverett. The reason why we put this together and constructed it the way that we did is because by using, this isn't somebody that you have that calls that sounds like, I mean, some of these crimes, I mean, they can take the voice of anybody in this committee. They can have you call anybody and, call it, I would want, here's a good one. And this is a kind of a personal story, if you don't mind me telling you one. It was about 10 years ago, I got a phone call. I was walking out of work, I got a phone call, and the guy on the other side of the phone, he says, hey, listen, I want to let you know, your wife was driving into a gas station and hit my brother. And my brother was really hurt and is in the hospital. He doesn't have health insurance. And this is where things got really dark. He said that, just so you know, he doesn't have health insurance. I have your wife. I have a gun to her head. If you don't send me $10,000 right now, I'm going to kill her. And that was, of course, I texted my wife and I said, hey, are you okay? And she texted me back, thank God. I'm in a board meeting, and I'm like, okay, well, this is a scam. Now, imagine that same scam, but you now have her voice that they got off of her speaking and screaming in the background. And now to me, that's taken something to a whole new level, which is why we did an enhancement. This is taking things to a degree that's just, I mean, beyond, I don't even know, I don't have words for it. But of course I did bother to let him know what I would do to him if I ever found him, but that's another story for another day. But that's the reason why we chose to do the enhancement route. And I feel like it was really fitting of the way the crime was perpetrated. So.
Number 8, Representative Neal.
Yes. Thank you to the chair. Thank you to the authors. I had a few questions. So my first question goes to Representative Panage's point. If we're repealing and replacing 161280, which would be the lesser of the code sections, what are we replacing it with? Like, in lieu of this, what are we actually replacing obscenity by itself with? Like, how are we compensating for that particular crime?
Are you talking about Section 2?
Yes.
Yeah, well, I think what it's saying is, and I don't always understand all the legalese here, but I think what it's saying is we're repealing the current version of 161280 and we're replacing it with the codes that's written in line 21 through 53.
Yes. So my question is, what are we actually replacing obscenity with? So we're losing that altogether.
I'd have to. I don't know what the current. I mean, I could look it up if you want me to, but.
Okay.
You want to answer your question?
Yeah, if you want to answer that, yeah, go ahead.
I'm going to have the attorney analyst, Mr. Brian Hines.
So the reason that was actually being repealed was because the current version of the statute is unconstitutional. There's a Cobb County case, and they found that the advertising portion was unconstitutional, so it would have to be repealed and replaced. Otherwise, there's arguments that the new version wouldn't be constitutional.
Okay.
And that's why he answered that question.
Okay, so I got some more thoughts on that, but I'll come back to that. Secondly, you're defining child on line 25 as anyone under the age of 16.
Mm-hmm.
And I think we have a definition for child already in the code.
And I believe that mirrors that definition.
I don't know, because I think I'm seeing something different. Hold on.
Yeah, listen, if we can make it 18, I'd be fine with that. I just
want, sometimes when we're changing things in definitions, sometimes we got to make sure it goes across the whole spectrum. And I just was, yeah, if the attorney can advise on that, I'm seeing a few things. I'm seeing something.
Okay.
1981.
We'll come back to that while he looks at that. Any other questions? All right, we got a whole slew of folks to testify this. I do want to call Robert Smith with PAC up here. We had a little Romeo and Juliet type, or just kids being, for lack of a better term, not as smart as they should be.
And Mr. Chairman,
Yep.
I've been working with Robert. We have a small amendment we need to. If
Okay,
at
we'll
all
take that
possible.
up. We'll take that up at the proper time.
Robert Smith, the Prosecuting Attorney's Counsel. The reason why the Romeo and Juliet statutes, with those provisions, and it's kind of a bit of a misnomer, those are in most of the sex crimes because there's this issue about consent and amongst teenagers. What sets this apart and why Romeo and Juliet wouldn't apply is that this isn't an instance where there's one party consenting to their image or to the action that the other person is taking. This is a crime where an adult is sitting down and typing in, I want to see a picture of blank, blank, blank that's computer generated. There's no identifiable child. And that's one of the questions is that language y'all passed last year helped free up a little bit because we've been basically using a bit of around the crimes we have to reach and get the computer generated images to be able to prosecute them. This is one of those instances where technology is outstripping the law. Does that answer the representative's question about Romeo and Juliet?
Number 7, Representative Panic.
My concern is, you said an adult would do it. There's nothing in here, or at least I haven't seen, maybe I missed it because it's a substitute, that doesn't allow a 17-year-old or a 16-year-old to be prosecuted under this.
That would make it a juvenile crime.
Not necessarily, I mean, there are juvenile crimes that are, especially if there's an underlying crime.
This isn't one of the ones that's called a SB 440, so that this would start, if you had a 16-year-old or a 15-year-old sitting down and typing out, I want to see this image computer generated, that would start off as a juvenile crime. That wouldn't start off as an adult crime.
Right, it might start as a juvenile crime and end up in Superior Court, which we see all the time.
But once again, the issue is why the legislature has, my understanding of why there's always been this notion of Romeo and Juliet is because of, in the two cases it's predicated on, were based on the issue of the other party involved having some sort of consensual act that allowed the act to happen. This is somebody sitting down and directly saying, I want to commit a crime. I want to create this image.
I mean, maybe it's a question of intent. You have a kid who's doing something stupid versus an adult who's using it for, gratification. Versus a kid who wants to send some pictures to their friends.
And is creating an image of someone under the age of 16. That's the other thing too. Is don't forget that we're not talking about creating an image of an adult. We're talking about specifically saying computer create an image of what is understood to be child pornography.
Okay. Thank you.
And that's.
I think you covered it.
And I would say that, as with just about every case, there's a lot of fact-intensive. Although that minor may receive a lewd picture from another minor that it was voluntarily given, that consent to receive the consent there to receive those sort of photos between those minors, although distasteful in our society, it's a totally different thing once you go from that consent to receive it and that agreement between them to receive those photographs from one another. It's a totally different thing to go and generate something totally different with AI. It's like your consent, I would imagine that this could get sticky, but the courts would probably flesh that out. I mean, I think it's going to be very fact intensive, as I just poorly probably put it. But, I think, that for the prosecutor I could foresee being presented as, and correct me if I'm wrong, I could see that pattern, yes, they had the permission to receive that photograph, but permission was not given to do anything else with it.
And there's already crimes on that.
Yeah.
Once again, but in what you're outlining, this is somebody sitting down and saying from the beginning, create this image, and then what they do with it next. So, and that's
okay. Number 8, Representative Neal.
Yes, thank you to the chair. So we were looking and we noticed that 1612-100, we do define minor or child as 18 years or younger. And so I think the question, I guess it'd be a policy question, and we'll have to contemplate at this moment, but I guess whatever the body would recommend to be that age. So it can be a little bit more consistent because it's 18 in the sex crimes statute.
Okay, well then, Chair has a question now. What other sections within this bill do we have such as this that, we've got a little conflict in the code? Because I know Mr. Scandalakis and I have lamented, and we've still got to work on this one day, but, making sure that we have the proper definitions that mirror one another.
Well, I guess my question is, when we were pulling this up, I thought the age 16 was some, case-driven number. I don't know where 16. I think maybe can we just hold on then? I think we got some.
We'll come back. It sounds like we might have a few amendments.
18 is the federal recognized image for the distribution of child pornography. A child or an image of a child under the age of 18 is considered child pornography. The decision to put 16, that's
it was being driven from something, and I just think we need a minute. To
So are you saying that under the 10th Amendment, we have the right to make that age even lower?
That's one of those things I always look at you guys and say that's a policy decision. If y'all want to make it 16, you can make it 16. If you want to make it 18, you can make it 18.
I'm fine with 18.
Yeah, you can't. The only thing I would, 18 is what the feds say, and then y'all can. I mean, it's up to you. You're the legislative body. I'm just the one answering questions.
Interesting 10th Amendment question. Number 16.
Trying to make sure I understand the issue that's being discussed. So the definition that Representative Neal was citing was that 1612-100, the definition of minor as being someone under 18, and well, but I'm assuming that could be done if we think there's a policy reason to make a differentiation in this particular crime of depicting an act of pornography. What is the age at which it becomes child pornography?
You're going to make it easier on me and on prosecutors because in terms of 16, 18, this would be one of those times we would have to have someone come in and offer testimony as to what the age of the image. It's a jury question as to whether or not the images of someone of that age. Those are all the factors involved. So if you're raising it up to 18, that's once again that's your decision. I'm sure some people would say make it younger. Some people would say that's up to y'all.
And there's also I think a question that Representative Panich had as to the age of the defendant was what she was concerned about, I think, is if there should be some sort of exception or allowance or mitigating factor if the defendant was not necessarily a minor, but at least of age where, my understanding is you are subject to prosecution in the juvenile system if you're a minor, but before you are no longer a minor, you're subject to prosecution in Superior Court as well.
If you're under the case which are off, if we're dealing with someone who sat down and created this image, if they're under the age of majority, then it would start in juvenile court. If they're an adult, it would start in Superior Court. If this is a felony.
But what is the age at which you go into big boy court out of juvenile court?
18. Age of majority is 18 as defined by the code, correct?
Yeah, it's 17.
17, excuse me.
But that's not the age of majority for a lot of other purposes in the code. But for determining jurisdiction of juvenile court, it is.
If we want to have but this is not a raise the age conversation, which is a much bigger issue.
Well, my point is just that what is a minor is different for determining whether or not you're subject to juvenile court jurisdiction or Superior Court jurisdiction as to if you're old enough to vote or do a lot of other things. So here we're defining minor for purposes of the crime, not the defendant, but the depiction is 16, right? Under 16. So at 16 you would not be subject to that. And I'm assuming there would be no restriction on our ability to do that if we felt like it was appropriate to make it a lower age. We also could make it 18, I'm assuming, if we wanted to. Okay. And then the issue of the age of the defendant is sort of one that's dealt with to some extent already based upon where you're subject to prosecution. You're going to get, I think it's fair to say you'll get different treatment. There's a different sort of policy to the disposition of a case in juvenile court as opposed to in Superior Court.
Certainly.
Okay. All right, thank you.
So code section 16-12-100.2. Let's see, subsection B1 says child means any person under the age of 16 years. That was passed in 2007. That was the Computer Electronic Pornography and Child Exploitation Prevention Act of 2007. So we do have that precedent there. Number 14. Our floor leader Hall.
Sorry. Thank you, Mr. Chair. Thank you, Representative, for bringing this. Quick question. So I'm going to go back to us essentially redoing Code Section 161280. And I remember we did this a year or two ago, defining and being very specific as to what material is obscene. And it seems that possibly the language now is not including and or as specific as what we had previously, and may or may not exclude certain material that we previously would have said would be obscene. And I know the constitutional part of it, and I think, Brian, if I'm not mistaken, you're referring to Section C possibly on the advertisement part. But was there a reason why we're essentially redefining obscene by taking out some of these specific acts that we had defined? And do you think that what we have currently, this language, is taking away some of these acts that we had previously defined as obscene?
Well, I'm going to give you my non-legal opinion.
Sure.
My understanding when we were putting this together was 161280 was already ruled unconstitutional. So I thought that was the reason why we kind of rewrote it the way we did, because it would pass that legal scrutiny. As for what specific in that was and was not, I really can't. But I would be more than happy to throw as much of this as we can. And if you have concerns of anything in particular that we haven't covered, I'd be definitely open to it. I just want to make sure we're staying within the. Last thing I want to do is see this thing get tossed across the street and then get thrown out. So.
Is it my understanding the gentlelady had this in her subcommittee?
We did. Not this session, no.
But the prior session you dealt with this same issue?
We did.
Okay.
And I'm sorry, Chairman, if I can.
Yeah, go ahead.
Robert, do you have maybe a legal response to that?
To be perfectly honest, I, until about 5 minutes ago, didn't know about the constitutionality challenge.
Okay.
So my attitude is if y'all include things or don't include things, that's your job, not mine.
Yeah, and I haven't read that case, so maybe we can and see whether it's just us trying to take out a certain part. But thank you.
All right. Any other questions? Okay. Well, everybody's percolating a little bit. And your case citation for that, what a name. This was 11th Circuit case. This, that, and the other Gift and Tobacco Incorporated versus Cobb County. I'll repeat that again. This, that, and the other Gift and Tobacco Incorporated versus Cobb County. Citations 439 F period 3D 1275.
What was the last?
1275. And that's 11th Circuit. For any nerds or anybody want to get it right.
So as long as we got that, because we're going to.
All right. So we're going to move on to testimony. Thank you, gentlemen. Representative Thomas.
Yes, sir.
Myself and others on this committee make a living out of questioning doctors from time to time while it's still legal in the state of Georgia. So if you don't mind just scooting over, don't want to get anybody sick just in case.
Just to be clear, the doctor cleared. I didn't come back and it's clear.
Thank you. Sarah Lou with GBI.
Chairman, I'm sorry. I'm slated to testify for House Bill 170. 161, I'm sorry, 161.
She's here. Okay. All right. That's right. Sorry.
I'm also eager.
A lot less sleep than I used to have. All right. I'll go with. Oh, I got you. Brother Mike Griffin. Good to see you again. When's your breakfast?
It was Thursday.
Of last Thursday?
Yes, sir, last Thursday.
I was a little occupied. I apologize.
Yeah, you were. You were taking care of mom and a baby.
That's right. That's right. Go ahead.
Thank you, Mr. Chairman, and we do appreciate Representative Thomas, and Georgia Baptist Mission Board supports this legislation. Paul Smith with Citizen Impact is not able to be here today. He supports this legislation, and Mac Parnell is here. If you'll let him speak in just a little bit. For Faith and Freedom Coalition, they support this as well. I am the Public Affairs Representative for the Georgia Baptist Mission Board, and one of the three areas that I do represent, not just the public affairs, but also I represent child protection policy for the Georgia Baptist Convention. And I was able to speak last year in 6 conferences on having child protection policy, dealing with sex abuse and those types of things. And we know that pornography is one of the major players in dealing with those that are exploiting children, predators that are out there. Georgia Baptist in 2017 passed a resolution, and we do represent approximately 3,500 churches and almost 1.4 million Georgians. And we passed a resolution entitled "The Moral and Social Public Health Crisis Created by Pornography." And so it's very important that we support this kind of legislation, because pornography has a tendency to normalize violence and abuse of children. And so we definitely support this. And I've also come to realize through my friend Greg Love, who heads up Ministry Safe over in Texas, we coordinate our work with him, that in 2022, for the first time on child sex abuse reports, for the first time 52% of those initial reports were peer-to-peer abuse. So because of child's access to pornography today, which is somewhere between 9 and 10 years of age, we're seeing peer-to-peer abuses going up. And so we don't need anything that encourages us to go in that direction. And so we certainly support this legislation, and we would certainly encourage the committee's favorable support for it. Thank you, Mr. Chairman.
Any questions for Brother Mike? See none? Thank you, Brother Mike. All right. Let's see. Graham Younger. Yep. And Maisie Lynn with Gactal. And I'll get to you.
Hello, good to see you all. I'm Maisie Lynn Girton from the Georgia Association of Criminal Defense Lawyers, and joined by Graham Younger, who is also working with us this session. Well, before the last conversation, I had a really brief set of comments, but I would like to address a few things that have come up today. And I would love to start with what Representative Byrd said when you all were considering House Bill 162, and that is that people do very stupid things. 15-year-olds do very stupid things, and they do it not like sitting at home at their computer the way Mr. Smith, painted the picture for you, and making a really decisive decision to build an AI-generated obscene picture. They do it on their phones between classes at school with executive function that is well below that of an adult. And those are the people that we're here to talk to you about today. I'm not here to talk to you about the people that we're scared of in this context, the true adults who are doing things that we find repugnant. But because there is no carve out here for children that are going to be implicated by this law, it's a matter worth discussing. In part because this body has carved out similar protections, as we've been talking about in a cursory way, in 16-12-100. And as Mr. Smith did say, the fact patterns that caused you to set forth a distinct policy for children in that code section were built on consensual high school dating relationships, which is why we have called that Romeo and Juliet. But I would like to just reframe that for you and just think about this as teenagers. There's nothing in 16-12-100 that requires the kids that are involved to be in a dating relationship, requires it to be a female and a male that are dating, a male and a male that are dating. Like, none of that is part of it. So when we think about it that way, and we talk about the consent part of it that way, it constructs a certain image that's just not legally necessary. What I would illustrate, or ask you to consider as an illustration, is you pick your team. A group of high school wrestlers, a group of high school cheerleaders, a group of high school basketball players, whoever it is that comes to your mind, just a group of teenage kids. And consider a couple of ways that these images might get created. One is they're sitting around and they say, wouldn't it be funny if we took my face and put it on an image of some other body? And I know no one wants to talk about what these images are, but I'm going to talk about it because we have to. A naked physical body of a person with breasts bigger than mine, and put their hands on them. Because if you go to 1612-100, that qualifies as one of these sexually explicit images. It doesn't have to be something grotesque. It just has to be sexual. And there are some things that are laid out in 1612-100 that are kind of grotesque, right? Like bestiality. No one wants to see that. But physical contact in an act of apparent sexual stimulation with any person's unclothed female nude breasts, that counts as sexually explicit conduct under these code sections that we're talking about. So it's a wide range of behavior here. And when we're talking about 15, 16, and 17-year-olds, you know, maybe they'll opt into the crazy things, you know, the bestiality too. I don't know, but the fact is they might do something just as simple as what I described, and now it's a felony prosecution under this new piece of legislation. And, you know, I said early, like, what if I'm agreeing to it, right? Because we've talked about how in 1612-100 there is a consensual production of a picture that is the predicate, that's a predicate variable that you need for that protective sentencing to come into play. But, you know, what if not? What if they do create the whole image from what I would call whole AI cloth, right? In that case, there's truly no child victim. And yet we're giving protections in 1612-11 when there is truly a child involved. And here we're saying, sorry, you're a felon, you 17-year-old. Or you transferred, you know, as you mentioned, Representative Panich, you 15 or 16-year-old who started in juvenile court because, you know, the initial people involved in this investigation thought, oh, kids are being kids, but we're still going to send them to court. Maybe we'll scare them a little bit in juvenile court. But for whatever reason, the state decides to move to transfer to Superior Court, and the judge agrees. And now we are in Superior Court, and we are prosecuting 15 and 16-year-old children as adults. And they're going to walk out with a felony conviction if it comes to that. So we have some language that we have offered to Representative Thomas today briefly in the hallway. Didn't realize how sick he was, so not sure that that conversation with Graham went as well as it could have. I mean, I don't, you know, didn't. But also in this, there's mirror legislation that's coming through the Senate. We've offered the language there, and I will just be honest with you, they rejected it there too. The senator sponsoring that bill didn't want to provide these protections there either. And the stated belief in the hearing was that judges and DAs are going to exercise their discretion to handle these cases appropriately. But if this charge is on the books, this is a tool in the toolbox, and it's going to get used. And it's going to get used against 17-year-olds, and it's going to get used against 16 and 15-year-olds, not just the 45-year-old person that is the scary illustration of this crime. So please, if you would consider modifying the sentencing here so that a similar scheme is available for 18 and under children who are prosecuted for this crime to be sentenced as misdemeanors. I'm not saying they don't get prosecuted. But we're saying let's give them a misdemeanor just like we would under 1612-100. And I also want to just name the age conversation that was happening around sex, because the age of consent to have sex in Georgia is 16. So that's it's another wrinkle in all of this. We talk about it every time sex crimes come up in this room. So I don't have any suggestions on what you do about that, but I think it's also just a variable to keep in mind that that's another layer on the age issue.
Number 16, Chairman Leverett.
So, Amazing, again, you're going to have to help me with the criminal law issue here.
Sure.
So, I understood that if you're 16 years old and you commit a crime, you're adjudicated in the juvenile system where any disposition would be confidential or wouldn't follow you forever.
Unless the case is transferred. So there's a provision, and I want to say it is 15, I know it. There's a transfer provision where a request can be made if a child is being, if the allegation against a child would be a felony, if it was alleged against an adult, it allows the transfer after a hearing to Superior Court if they are 15 or 16. It can go younger, it can go younger if the penalties are higher, but this particular crime would qualify just for that 15 or 16-year-old to potentially be transferred to Superior Court.
And is that the same statute by which they might prosecute a child that commits murder or?
No, that's a different one. So
That's
that is the one that ends in 560. It's 15, either 11 or 12, 560, and then this one is maybe 561 or 562. They're all right there together in Title 15. The one that you're talking about is what we colloquially call Senate Bill 440, because that's what initiated it, and that's the however many deadlies we have now, where that's concurrent jurisdiction. So from the moment they're arrested, both courts have concurrent jurisdiction. In this situation, juvenile court has, like you said, the 15, 16-year-olds, they're going to squarely fall into juvenile court to start. But if a motion to transfer is made and the court agrees, then it's going to go to Superior Court.
I guess, I appreciate your concern, and I kind of see it. But I would think the existing processes in the criminal system would provide some infrastructure where the result we think would be bad, the sort of overreaction or the extreme punishment of a child who just did something stupid because their brains aren't wired, could be prevented in that existing, because presumptively they're not going to get sent to court and tried as a felon in an adult court. They would stay in juvenile. There is a possibility they would get transferred, but I would think there's sort of an infrastructure that would generally not, most of the time would not allow that to happen unless there was a really good reason to do that.
Well, I think my cynicism about our criminal legal system must be a little bit higher than yours.
You think I'm being a little Pollyanna, do you?
Possibly.
Okay, all right.
And I say that in a cheeky way, but I'm also kind of serious because we have now 51 district attorneys exercising their own individual discretion based on their own local community norms, which vary greatly across our state. Your districts vary greatly, and what might be considered fun and games where you live might be very serious where Representative Panich lives. And so and even if we take it out of the 15 and 16-year-olds and just talk about the 17-year-olds who are certainly going to be prosecuted in Superior Court, yes, it's possible that a DA in one jurisdiction might say, you know what, I'm going to kick this. Maybe the solicitor wants to charge disorderly conduct or some other misdemeanor so that it's just not a felony, whereas another might not.
But I didn't understand, I'm sorry to interrupt, but I didn't understand it to be a charging issue. I understood it to be a jurisdiction and process issue. In other words, if you are under a certain age, you're in juvenile court presumptively.
Sure.
And it's not so much, you could be charged with one of these crimes, but the disposition is going to be significantly different, as is sort of the impact on your permanent record. Yeah.
Right. Oh, well, certainly. The same holds true. I think it's the same, I guess my same argument would hold with whether or not the case gets transferred. Whether or not the motion to transfer even gets filed, right? Some DA's never going to file that in a case like this for a 15-year-old. Another might. Like maybe it's time to make an example of someone. Like there's legislation on the table in another context to make examples of children who behave badly after a school shooting in our state. Mm-hmm. So we know that there is an impetus in some situations to choose some kid to make an example of. And so I'm back to my cynical thought, and that's just a subjective nature of discretion that is warranted, but it's going to be vary greatly in all of these all the decision points along the way. And so the only way to ensure that there is some equity for these children is to set up a system like you have in 161211 or something similar, so that they are all treated in similar fashion, irrespective of where they're prosecuted, simply because they're children. And we're going to recognize that their behavior is fundamentally different than that of an adult behaving this way.
Well, and I acknowledge that position. I guess I just feel like every case turns in its own facts, and that's why we, at least traditionally, we have tended to give discretion to the local officials. I know that hadn't always been the trend lately, but that has been the tradition.
I think, let me interject real quick. I think maybe what it does turn on prosecutorial discretion. Maybe, and if I'm suggesting something off topic, tell me. With the Victims' Bill of Rights, although a lot of prosecutors may feel, predisposed to treating them as a minor, if this may be referred up, I mean, that intersection has, for, in good ways and maybe not so good, has hit a crossroads that, prosecutors from experience in crimes unrelated to this, they feel a little hemmed in by that. A common response I get a lot of times is victims not having it, which I think that speaks to the human nature that we have to deal with as policymakers in a fallen world, that, everybody's naturally going to want that pound of flesh. And so I think maybe that's something that we as practitioners have to deal with, and I think prosecutors share that same concern from time to time. It's a difficulty in more cases than what we might realize.
Yes, sir. Well, and I think, too, as you raised the point, it to me is, as a matter of policy, do we want to set the rule to apply across the board in every case, or do we want to allow the possibility for some variation based on facts? But I think your point's well taken, that also would allow for the possibility of results we may not like in a given case.
And we are dealing with a textualist majority over across the street, which I think we have to be mindful of that.
Yes, sir.
All right. Any other?
I do have one other thing just to follow up on from the earlier conversation, and it's also the question that you raised, Representative Leverett, around whether this can be prosecuted now. I know that there are people here from PAC and at least one district attorney in the room who might disagree with me. But in 1612-100, just last year, you all closed what was considered by some a loophole that was allowing the defense to raise the issue that this was a fabricated image, and so therefore shouldn't be prosecuted under 1612-100. I would be surprised to hear that there is an impossibility today, based on what you all did last year, to prosecute an image like this today. But I would be willing to stand corrected. Not that it might not be difficult, but I don't think it's impossible today. I know you asked that. Chairman, if you would like, I have a potential amendment that would account for the teenagers, if you would just like to have it to consider.
At the proper time.
Graham gave you.
Yeah, at the proper time. I will say this, I think there was a case in my home circuit that dealt with this, because I remember having a very interesting conversation in the tool store about why is that criminal. The very thought, that kind of mindset that this legislature has made a stand saying that is not something we want to be allowing our citizens to, go out there and have, and like the very possession of it. I think there was some discussion at length over this, where does that conduct end up going eventually? It's going to go from just artificially created images to real images, if I remember that discussion correctly. We'll get to that
Thank you.
at the proper time. Let's see. Who else do I have? Chelsea Thompson. Well, Frontline.
Hello, Chairman, members of the committee. So my name is Chelsea Thompson. I'm General Counsel for Frontline Policy, and I want to say we're standing here in support of HB 171. We also want to thank Representative Thomas for bringing the bill and for PAC's work on the bill. So I agree with the intent of the bill that it expands the code to include misuses of AI-generated images, addressing the advances in technology and loopholes in the code currently. And even though some, I think we've heard some things bounce around about the struggle of kind of finding the victim is, the content is harmful, and this legislation helps combat, we would argue, normalizing sexual exploitation, harmful culture, and potential encouragement of criminal behavior. Sorry, maybe I'm too close. And this bill also furthers preserving the integrity of our child protection laws currently in the Georgia Code. Something I will mention is, as a few members on the committee have already mentioned, is take into consideration, obviously, the constitutional issues that were brought up. I'm a little concerned with repealing the entire code section of 161280 in that certain contents of obscenity that may not be captured as computer generated, and we're currently unlawful under 161280 will now be left out. And so other code sections seem to be exclusive to child exploitation as opposed to 161280 was a little more broad. So I also would like, Chairman, if it's okay, I'd like to bring up, I was talking with Herb, actually the DA from my county, and I'd like to see if I could bring him up to kind of share his concerns as well, as we were kind of communicating about it prior to the committee.
Sure.
Thank you, Mr. Chairman. I'm Herb Cranford, DA Coweta Circuit. Ms. Thompson is one of my constituents, actually lives in Noonan. But yeah, we were talking about this, and I had not seen the current version of this until I sat down here, but in kind of talking and texting about it with some other prosecutors and people in the room, the current version of 161280 is pretty broad. It's a misdemeanor. I'm not familiar with the 11th Circuit case. I believe Mr. Hines said that was an advertising issue. But I just want to make everybody aware, like my current understanding, and maybe I'm wrong because I haven't looked at this with great detail, is the new version has elements that require made by an artificial system, and it only deals with children, whereas the current version deals with any kind of created material, not necessarily AI created, and it doesn't necessarily deal with children. Granted, it's a misdemeanor, but you can imagine a scenario where adults get obscene material that they distribute that the object of the image doesn't want distributed. And so I do have some concern again with a little bit of maybe ignorance of exactly the interplay between the old version and the new version, that by repealing the old version and replacing it with this, there'll be some behavior that becomes lawful that is currently unlawful, that is currently allowing us to protect people from having obscene images of themselves distributed. But I will say, I want to be clear, I really agree with what this bill is trying to accomplish, and I think this is really a valuable piece of legislation. And to the issue that's been raised, I can't imagine a juvenile judge transferring a case to Superior Court, as was suggested in a hypothetical. I don't think I would be trying to do that. So I do have some confidence. Granted, I'm a DA, that the current process in place where elected DAs and a judge are, kind of making those decisions, even with upset victims, I feel confident good judgment is going to be used.
Number 14. Chairman Gull.
So this might be actually more for Council Bryan. Is when was that unconstitutional ruling happened? It happened in 2006, like a long time ago. Okay, and so if it happened a while ago, and we passed a bill last year that changed it, doesn't it put it back for them to restrike it again? I'm just trying to work through that.
So the one we passed, this committee passed the last year, didn't actually receive final passage. So
Okay.
it would still be by itself. And just for what it's worth, I'm trying to look through this case now just to refresh my recollection. It was definitely unconstitutional in part. The problem was the 11th Circuit case was unclear as to whether the rest of the statute was. And they went back and forth, back to a district court. They overruled the district court on a rule of the case logic, I believe. And so I believe that's why that decision was made. So I'll defer to you, obviously, if you all are able to prosecute this right now, but it's at least in part constitutional. The other one is up for debate, I would argue, just based on their wording.
Thank you.
Sorry, I hope that answered you.
I know there's not always a lot of these cases, but have y'all had one yet?
If I recall correctly, I think we've charged people with misdemeanor, whatever the language is, obscenity, essentially. Yeah, it'd be along with some other charges. Like I want to say, it might have been involved, some kind of stalking type situation, and I think involving adults, and there was a worse felony charge, but some images were distributed that the former significant other did not want distributed, kind of thing, if I recall correctly.
Okay. Number 14, Floor Leader Hall.
Thank you, Mr. Chair. D. Cranford, can you give us your opinion on what Gactel had discussed regarding the Romeo-Juliet issue, and whether or not you believe we should add specific language, or if you believe that the process will...
Yeah, granted, I'm a DA, but I'm more inclined to Representative Leverett's view that the current process in place has two people, who are serious about their jobs, using their discretion to try to do the right thing and not, be unnecessarily tough, or however you want to describe it. One thing that occurred to me, typically Romeo and Juliet laws, it's for a defendant and victim if they're both between the ages of 14 and 18, right? And I don't recall the Gactel representative referencing the floor of that, which would be 14. So, now granted, we're talking about artificial images, so like what's the age of a victim in this scenario, right? But I don't think this committee, I know I would not support, a so-called Romeo-Juliet law where a 15, 16, or 17-year-old could create a bunch of egregious images of an adult doing something bad to a prepubescent child, right? Like Romeo and Juliet laws are, for people that are essentially in high school together, is why it was created. And so, I think by saying, anybody under the age of X that did this should be treated as a misdemeanor, as if it were a Romeo-Juliet situation. With AI, that's not a clean comparison, I don't think, if that makes sense.
All right. No other questions? Thank y'all.
Thank y'all.
Appreciate
Thank
it.
you.
Let's see. Who else do I have, Brian?
71, so that's it on that one.
Okay. I think that's all on 171. Let me see if I got any other. Anybody? Oh, yes. Come on. Faith and freedom. Can't leave Ralph Reed organization out. That's right.
Mr. Chairman, thank you so much. I apologize for my late arrival. I wasn't able to sign up. I was battling. I had some business away from the Capitol and was battling the rain and the traffic. And so thank you so much for the brief recognition. And congratulations to you I understand congratulations are in order. I have a 10-month at home, so you look pretty incredible for what you've got at home. And I see you've only got 1 cup of coffee. Maybe we need to get 3 or 4. But Georgia Faith and Freedom Coalition, we're in support of this legislation. We appreciate Representative Thomas's, I guess Chairman Thomas's his hard work on this, and it's a sad state of reality that this is a discussion that we must have, but AI is coming. AI is already here. Hundreds of billions of dollars being invested in it, and I appreciate Chairman Thomas getting ahead of this issue. Thank you.
Any questions? All right, thank you. Okay. Representative Thompson, I'll give you the final word.
Thank you. I do have a couple small comments specifically about the group of wrestlers in the room. That I just want to make it clear that the crime here is to commit the offense of distribution, okay? And specifically line 40 says depicts an image of a child and to be of a child and would appear realistic to an average observer. I don't think putting one of the fellow wrestlers' head on a female body with is necessarily going to be realistic to the average observer. That's not what this crime is going after. This is not what we're looking to do. We're talking about the group of wrestlers in a room. Not calling out anybody particular, just using the reference that was brought before, and that create an image of a young girl doing things that are obscene and sending that around the school because maybe she's not the coolest kid in the class. That's what this crime is about. And I'm sorry, but I don't really have a whole lot of mercy for or patience for people that are willing to do something to humiliate another human being, because here's the simple fact: once you put it on the internet, it's there forever. It doesn't ever go away. This will trail that person for the rest of their life, and I don't have a whole lot of empathy for somebody just because they're 16 years old and did something stupid. But of course that was just the way I was raised. You got to have respect for other people, but this is far beyond anything that's ever happened. This isn't just you get to go home at the end of the day and it's just over with. This will haunt you for the rest of your life. And so I've got personal feelings. I'm sure you can hear the passion in my voice and over the frog. But I think this is important. It's an important piece of legislation, and I appreciate the committee spending this much time on it with me today. And I'm always open and happy to, give myself to the will of the committee. Obviously, I'm for pass, but I understand whatever the will of the committee is what I'm willing to do.
Okay. We're past the question phase. Floor Leader Hong, you got something to
Or just had a quick
discussion?
clarification question?
Yeah, okay, go ahead.
If I may, Mr.
All
Chair,
right.
Representative, just to clarify, this bill is changing the code section and only addressing computer-generated obscene material, correct?
So,
Not any, publishing or paper or just non-computer generated, I guess. I don't know.
So it defines obscene, right? Lines 26 through 35, and it says the crime is the offensive distribution of computer-generated obscene material. I would agree with you on that. Yeah, I mean, the way that I read it, I would say that's an accurate assessment. I don't, again, that was predicated on the fact that I've always had this understanding that 16, whatever, is
and I certainly
ruled unconstitutional.
And I think your work is good, and I get the intent, and I think that's important. My concern, and Chairman, if I may, my concern is us essentially taking 1280 and turning it into a more narrow description or definition of obscene material, and we're only focusing on computer generated versus other things that we have previously listed. That's my only concern, that if we can try to see if we can look at possibly inserting this into the current code section, whatever it may be or may not be constitutional. I think we can discuss that as well, but I don't want us to go back and forget about the non-computer generated obscene material that we may be getting rid of.
And Chairman Thomas, I think something that a lot of us lawyers probably have in the back of our mind because they teach this case, or they used to in law school. There's a case involving Jerry Falwell's mother and her face being exposed on a naked image in Hustler magazine that went all the way to the United States Supreme Court. And that's the constitutionality of that. Correct me if I'm wrong. Supreme Court said that was fair game. Now, it was a terrible thing they did to Jerry Falwell's mother, but that's something that all of us that are practitioners have in our mind, that we want to make sure that, we don't leave this wide open.
No, I would agree with you on
So,
that.
just so you know.
My understanding is, and this is very limited. There's a lot of code sections I can sit and chat with you about, not this one. But my understanding is, there's multiple statutes that cover obscene material and children and, child abuse. I'm fine with it. Listen, if you want to add something in here that you think makes this more comprehensive, I am 100% supportive of that. I always will be. And we have no problem editing it. I just would like to, if you have anything, it sounds like you have something kind of in the back of your head in particular, and I'd be happy to incorporate that in if that's.
And I think we just need to look at the constitutional case. If I can look at that, and then
absolutely.
I think we may have a suggestion later. Thank you.
Okay.
Thank you.
Any other discussion? All right. Chairman Thomas?
Yes.
We are going to send this to Skunk Works and
Sounds good.
get this on the fast track.
Yeah, that sounds good.
So I'll speak with you after, either by text. You go home and get some rest, and we'll get to work on this. I think every member here believes in the purpose of this. We just want to make sure we get it right. Whereas we're unlike the state senate. We're not just gonna,
Send it on through.
We're not gonna have a mistake go over to the other side and get it struck down. So we'll fast track it.
Listen, like I said before, I appreciate the committee. I appreciate y'all spending the time on this. I do want to get it right, so we're sharing that. So we'll come back and once everybody's comfortable with it. And thank you for hearing it today. Appreciate it.
Thank y'all. All right, Chairman Crow.
Yes, sir.
You can just present from right there.
Okay.
Which number are you?
Number 12, sir.
All right. House Bill 161. Go ahead.
All right, we'll let the other interested parties
Keep it
file out a little
down. We're
bit.
still doing some business in here. If you got conversations, take them outside. Thank you.
Okay. Thank you, Mr. Chairman. This is House Bill 161, as you stated, working from LC number 394507, and it's essentially just adding a couple of crimes or code sections, giving the director of the GBI the ability to generate an administrative subpoena for production of communications evidence from communications companies, telephone companies, for computer and electronic device crimes, and that currently is already able to be done for code sections 1612-100, which we just had a robust discussion about, 1612, 100.1 and 100.2, as well as Article 8 of Chapter 9 of Title 16, which is identity fraud statutes. It's reordering it some, kind of rewording it a little bit to make it more in line. But then it's also adding code section 16993, which is computer crimes of several different types. 161028, which is a swatting code section that we added last year. 161137, which is terroristic threats and acts. 161139.1, which is harassing phone calls. And 1611.221, which is domestic terrorism. It is also in Part 2, Section 2.1 and 2.2, there is some cleanup language, just redefining it, because we had this reference to 1611.221. The actual definition was in 1611.220, but the offense of the crime was in 1611.221, so I kind of cleaning that up a little bit. This is the way I talked with Jenna in the legislative counsel's office. She thought this would be the best way to kind of go ahead and do this while we're doing it, get it cleaned up a little bit so we can reference one code section that the crime and the definition of it is there. So with that, I am happy to answer any questions, Mr. Chairman. That is the extent of the bill, and there are some representatives here from GBI that can speak much more intelligently about the details of this than I can, if you'd like to hear from them.
Okay, I'll go ahead and have y'all come testify. Miss Sarah Lou, I've been wanting you to come up here all day on every bill.
It's your turn now.
So, anyways, welcome. And you got a friend with you, Philip Curtis?
Yes, sir.
Okay, good, good. Go ahead.
You'd like me to start?
Thank you, Chairman and Committee, for having us today. Thank you to Representative Crow for sponsoring this bill. We are very concerned about the rash of swatting cases that we have seen in Georgia. In the past year, starting in December 23, actually, we worked a very large swatting case that affected multiple public officials in Georgia, not only in Georgia, but across the nation. And one of the difficulties that we have with any case that involves cyber-enabled threats, and what we define that as using a computer or any type of electronic service provider to transmit these threats, is that we have issues with identifying subscriber information for these subjects. What do I mean by that? That means essentially very simple information: name, address, IP address, Internet Protocol address for where that account was started. And at this time, when we have a swatting case, and I'll give you a great example. This morning on the drive here, the GBI was requested for a swatting case located in a rural Georgia county that involved a juvenile suspect, the voice of a juvenile suspect, which has yet to be determined if that is AI generated. The suspect called the 911 center of this rural county and indicated that he had shot his mother and that he was getting ready to shoot neighbors in his area. We have had cases where pipe bombs were, a threat of pipe bombs at schools were located to 911 centers. We've had indications that someone has been shot and there were hostages with voices in the background. These are real threats to life that we are receiving in 911 centers. Right now, our remedy is to either obtain a search warrant for all-conclusive subscriber information that actually includes data from these electronic service providers, but we have to go to that jurisdiction and issue a search warrant issued by the judge, or we go through a grand jury subpoena, in which case grand juries are not always in session. This bill would allow us to act with expediency for these threats against public officials, schools, terroristic acts and threats, and we would be able to identify through the assistance of our director's office, but also the Attorney General's office, to obtain that simple subscriber information from these electronic service providers. And we currently have this same system in place, as you mentioned, with our child exploitation unit and identity theft. This is a very powerful tool that we can use in investigations, like the one this morning that we were contacted about and the GBI is assisting in a rural county with. And threats to life are taken very seriously by the GBI. We worked over 500 threats to life just this past fiscal year. And there are issues with determining whether these threats are true or false. When they're true, in the worst case scenario, we're looking at a tragedy such as we experienced in Barrow County. When they're false, we're looking for attribution. And in the cyber world, attribution is determining who the bad actor or the subject is and determining jurisdiction and venue. And that's something that we can do if we are allowed to issue these administrative subpoenas to electronic service providers.
How do y'all go about your subpoenas now?
At this time, we only have administrative subpoena power for our child exploitation cases and identity theft. So at this time, we have two options. We have the grand jury subpoena process, or we have search warrants.
And this legislature in the past has granted limited, but we have granted extraordinary powers to the GBI to correct certain issues.
That's correct.
Okay. I'm thinking about back in past decades dealing with the Dixie Mafia, for instance. I think there's a county, y'all probably still have exclusive
The
jurisdiction.
original jurisdiction, yes, sir.
Which one is that again?
That is Jackson County.
We got anybody from Jackson County? Represents Jackson County?
No, Butts County.
That's right, that's right.
Sorry.
Very different.
Jefferson area.
Yeah, that's,
Sorry.
yeah, Jackson, Georgia, city of Jackson, Butts County is the great area I'm from.
That's where the dragons are, huh? We'll keep that in place. Number 7, Representative Panich.
Thank you. Thank you very much for this. I just have a couple questions. So I served on a grand jury as a 4-person. I issued subpoenas, so I understand why that's not a good idea, or you can't wait that long. How long does it normally take you to get a search warrant? And do you have to go to that jurisdiction? And what if, do you even know what jurisdiction it's in if it's a phone call from somewhere?
It depends on the electronic service provider, and it depends on where the threats were actually issued. So we could have a threat that's in Rome that's going to take us at least 3.5 hours to get to if we have an agent that's in South Georgia. So expediency is the issue, and trying to identify who these subscribers are, and that this would aid us greatly.
Are there not, and I'm not on the prosecution side, so I don't know the answer to this. Are there not you can make an application on, over the internet with the judge, the magistrate?
Unfortunately, it's very limited at this time.
Okay, thank you. That's what I needed to know.
Judge Weaver, I know you were out earlier. Just wanted to pause real quick and recognize you. Hope everything's good up in Pickens. And please give my best to your son, who I was in law school with for a little while. He was a little bit ahead of me, but George's a good guy. And so, good to have you with us. Thank you.
He was in court today.
Good lawyer. Good lawyer. Okay. Going back to the bill. Any other questions? Number 13, Representative Byrd.
Thank you very much. I just want to be sure that I totally understand what you're asking. So you want to expand your powers so that whatever jurisdiction may give you the subpoena, then you can travel across the state of Georgia to find that particular person.
This is actually for administrative subpoena power in conjunction with the Attorney General's office, so that we can issue an administrative subpoena that would only go to electronic service providers, so not a search warrant, electronic service providers, to just identify that simple subscriber information: name, email address, IP address, possible address of whoever set up an electronic service provider account. So let's say that you have a Facebook account, and that's where the threat was transmitted from. We would be able to issue an administrative subpoena through the Attorney General's office to submit that to Facebook, not for any data, only for subscriber information, to identify who that bad actor is.
Thank you. Just another follow-up. So,
hold on a second. Number 14, I'll come back. Number 14, Chairman Gullett.
Yeah. I like the bill. Only thing I'm not connecting is, like, what does expediency get you in this situation? So the call's been made. Like, are people no longer there? Are they deleting information that you don't think you can get later to prosecute? Like, what does the expediency get you?
It saves us travel time, and also that's the largest thing that it allows us to save travel time, as opposed to going to a jurisdiction, a judicial circuit that is hours away from where an agent may be located. And it allows us to get the IP address is really important, because that gives us a location for where an account was established, and that also gives us jurisdiction and venue. So that is what saves us an incredible amount of time on a threat. And our goal is to stop the threat to life. That's our ultimate goal.
Sure, but I mean, the events happening is occurring at the moment, right? So a swatting call has happened. I'm sure police are dispatched, and whoever else is dispatched to handle the situation. This is really after the fact. Hey, this was a SWAT, because you don't know it's a fake call until you get there and family's playing in the yard or whatever, right? And so the expediency is really a convenience expediency, as far as like it's not time sensitive as like life or death time sensitive. This is time sensitive as far as how to make this expedient, the process just better.
It is not just based on convenience. It is definitely based on limiting and identifying that threat to life, because what we're seeing now is these are so much more common than they used to be. So the case that we worked starting in December of 2023, there were over 579 calls made within a series of weeks across the nation. And the problem is that they are becoming more frequent and one on top of another. So we are endangering public safety every time one of these swatting calls is executed. So it can prevent us, with administrative subpoena power, we can identify that subscriber, and a lot of times they are coming from the same user. And so that when subsequent calls come in, we're able to identify the threat.
Okay, thank you.
Number 16, Chairman Leverett.
Thank you, Mr. Chairman. Thank y'all for your testimony today, and Representative Clerk, thank you, or Chairman Crowe, thank you for bringing this bill. Trying to make sure I understand. So an administrative subpoena is basically a subpoena that is issued by somebody in the executive, rather than having to go obtain any kind of court approval for it. Is that?
We go through the division director's office, and then it's in conjunction with the attorney general's office. Yes.
But you don't have to get any kind of, there's no court oversight of it, I guess, to be fair.
A judge does not sign these.
Yeah,
correct?
yeah. And to be fair, in civil litigation, I can issue those all day long as one of the parties. I don't have to get court approval to subpoena somebody. So right now, you were saying you can only utilize an administrative subpoena for certain, like child crimes.
Child exploitation.
Exploitation crimes. And I was trying to find in the existing statute where that limitation appears. It doesn't, from just looking at the bill and the change. Oh, it's stricken from the front of it. So we moved it down to the bottom now. Okay, yes, I see we're reformatting that. And as I read it, to your point, that doesn't allow you sort of a wide-ranging fact gathering. There's A through F specific things that you can get. So the administrative subpoena was supposed to sort of a balance of the fact that you don't have to obtain any sort of court approval for it. It's very limited in the type of information you can get.
Yes, sir. Very.
As you said, it's name, address, local long distance connection records, which would be when they connected and when that was gone, length of service, during the start date, telephone or instrument number, other subscriber number, identity, means and source payment for the service, and that sort of thing. So that's all you can obtain on these.
Very limited.
And to Chairman Gullett's question, even by the time you're issuing the administrative subpoena, there has, I would assume, been some lapse of time between the occurrence of the incident and your connection or contacting the service provider, who it is, to get the records, correct?
Yes, sir. Typically, there's been an initial threat, and then as a GBI is a request-only agency, we have to be requested by those entities, local sheriff's office, et cetera.
But to follow up on this question, you may have answered this. I've been sort of distracted here. I think the concern he had is this is a little faster, but is it materially faster so as to really make a significant difference from an investigative standpoint? And I'm assuming you would say yes, it is, but I wonder if you could just elaborate on that for me. I guess it's a difference between several hours or 24 hours and 4 or 5 days or a couple of weeks.
Absolutely. Time is critical. Any cyber-enabled crime, time is critical. And so to allow us to have a couple hours in advance of actually identifying a bad actor can save public safety, the safety of public safety. It can save revenue, and it allows us to identify who these bad actors are, so that when subsequent calls come in, we've made significant headway on the investigation.
Thank you.
Any other questions? Okay, thank y'all. Appreciate it very much.
Thank you for your time.
All right. Maisie Lynn and Graham Younger.
Sorry. Conference. I'm going to be the fastest of your whole day, Chairman. We coordinated ahead of time with Chairman Crow and with the GBI to request a modification that would simply ensure that Defense Counsel receives copies of these subpoenas within the discovery process, which would be adding at line 70, where it now says the extent necessary for the issuance and compliance of the subpoena. We would be adding and compliance with Articles 1 and 2 of Chapter 16 of Title 17. That's the discovery, yes.
Anything else?
That's it. So, see, fast. I told you, fastest of the whole day. I get some kind of award, right? Reward.
Yeah, we work well together ahead of time.
Yeah. This one, he's good.
Graham, I think you were here one time last year. If you'll just introduce yourself for members of the committee.
Well, my job here is to let Maisie know if I think anything needed to be corrected. And I haven't spoken today.
Okay. Well, let me be a little bit more specific then.
Okay, there you go. My name is Graham Younger, and I'm a policy advocate for GACTL this session.
Right. And you're a practitioner yourself as well.
I am, yes.
And you know, you've had some experience in criminal defense.
I have not had.
Okay, gotcha. Okay, thank you. Yeah. All right. Any questions for Maisie Lynn or Graham? All right, thank you.
Thank you.
Okay.
And thank you, Chairman.
All right. Chairman Crow, you want to have final say?
I'll be happy to, Mr. Chairman. Thank you. Just a couple of points on the speed and expediency. And mind you, it's been a number of years since I've had the fortunate or unfortunate opportunity to obtain a subpoena for the production of evidence or a search warrant for this type of information. But I can tell you it is an arduous process, long and time consuming many times. And I was in Henry County where we typically had a grand jury impaneled, and it would still take a number of days to get that done. So the crimes are happening now much faster. I think to Chairman Gullett's question, the expediency, even on something, and some of these, the terroristic threats, the domestic terrorism, things like that, it's intended to try to help identify the actor and stop it before it happens, or identify whether it's a credible threat or not. On the swatting, they're not just going to do one. They're going to do them repeatedly to many, many people. So the faster they can be identified, the faster we can stop it, and the less chance there is of more responses happening in first responders or persons in the home where they're getting sent to getting harmed. So I think that's the expediency need of it for me, and I think it's a tool. It is very limited, and there is oversight from the Attorney General's office. So that's I think that the change in criminal behavior precipitates this need a little more than it used to be. So I appreciate the committee's consideration.
Okay. Any discussion from members of the committee? So I think maybe correct me if I'm wrong, Chairman Gullett, this is a change from judicial oversight of an executive agency of whether a subpoena is granted or giving it to the Attorney General. So taking judicial oversight away. Is that correct? Kind of where you were going with that?
Yeah, and that's okay to me. I'm just trying to see at what cost. Like, so what's the benefit of doing that? So how much does the, speeding the process up get us, and is that speed worth the change? That's kind of where I'm at. And I think I'm there. I mean, I don't think I'm not a no. That's just kind of where I'm trying to get my brain around. What is it? Not being in this, not being there and really understanding the full impact of that. That's what I don't know. It's kind of what I'm relying on everyone else. But is that a good change? Is the risk of that worth the benefit of the time? That's kind of, I guess, really the question.
Representative Byrd, you had a follow-up a while ago.
It's all right. Thank you.
I mean, if you want to pose that question, just, not to any one person, I mean, go ahead. I want to give you that opportunity.
Sure. So my concern is this a risk to civil liberties of the people of Georgia? I mean, if we're changing the process.
I'm not going to answer it, but I think it's a good question to chew on. Yeah. Any other discussion? All right. Chairman Crowe, we don't have a quorum. We'll come back. We're going to have another meeting, so we'll get this worked on. So I appreciate the GBI coming out. Give my regards to Dr. Darsaw. Is she still with y'all? Give her my regards whenever y'all see her, please, and regards to Director Hosey as well. Thank you. No other business being before us. We are adjourned.